Hello, my name is Ed Gralmick. I'm with the National Low-Income Housing Coalition. Welcome to Part 4 of Getting to Know the National Housing Trust Fund Law and Regulations. Part 4 is all about how you can use the National Housing Trust Fund dollars. Some of the topics that we will be considering are just general considerations: the form of assistance, eligible project costs, eligible operating cost assistance, operating cost assistance reserve, general program administration, discussion about public housing, and some key time frames. Homeowner features are eligible activities, but those are discussed in Part 5. So in general, the National Housing Trust Fund must be used to buy, build, rehabilitate, or preserve either renter housing or homeowner housing. Trust fund money may also be used to operate trust fund assisted rental housing. Trust fund money may also be used to help first-time home buyers with down payment and closing cost assistance. A reminder, the trust fund law says that no more than 10% of a state's trust fund allocation money may be used for homeowner activities. The trust fund assistance can be used in the form of loans, including no interest loans, deferred payment loans, could be grants, interest subsidies, equity investments, and other forms of investment that a grantee, a state or local subgrantee may come up with. And the terms of whatever a loan or grant a state might come up with is up to the state or locality to decide. The regulations go on for quite a bit about eligible project costs, and here you can see a list of some of the key features. You can use trust fund money for projects to buy property, use it for development hard costs related to construction. You can use it for relocation, demolition, utility connections, site improvements, various project soft costs, for example, architectural, engineering, and other related professional services, affirmative marketing activities, and the ever-popular builders and developers fee. You can use trust fund money for refinancing, but only if that's a small part of the overall use to rehab a particular trust fund assisted property. You can use it for construction loans and staff costs directly related to carrying out a project. In addition, you can use trust fund money for operating cost assistance, which is the next topic. Trust fund money can be used in conjunction with trust fund assisted rental homes to provide operating cost assistance and or to provide providing operating cost assistance reserve. This is very different from the home program. In case you're not familiar, operating cost assistance covers the gap in the rent that people are able to afford and the actual cost of running a property. Operating costs include things like maintenance, utilities, insurance, property taxes, and scheduled payments to a reserve for replacement account for major systems like roofs and air conditioning units and things of that nature. The interim regulations say that up to 33% or up to a third of a state's trust fund allocation in any given year can be used for operating cost assistance or for a reserve. That interim rule allows a grantee to commit funds from a National Housing Trust Fund grant, and I apologize for the gaps in there, received in any single year to provide funds for operating cost assistance over multiple years. Grantee can renew an operating cost assistance agreement with future trust fund dollars during that 30-year affordability period. However, funds committed in that single year must be spent within 5 years. All trust fund money must be spent within 5 years. A very important feature of the interim regulations allows for an operating cost assistance reserve to be funded upfront for trust fund assisted units to ensure project feasibility for these trust fund assisted units during the entire affordability period. And again, the affordability period is a minimum of 30 years. This applies mostly to any non-appropriated trust fund money, such as assessments coming from Fannie Mae and Freddie Mac, the dedicated sources of funding that we are initially having for the trust fund. We don't know that there are ever going to be appropriated funds, so don't worry about that. And again, the reserve applies to the 1/3 cap as well. Another eligible use of trust fund money is for general program administration. The law limits to 10% the amount of a state's annual allocation of trust fund money to general program administration. And this just relates to overall trust fund program management and monitoring. Some examples include preparing reports to HUD and ensuring that projects assisted with trust money comply with the law and the regulations. And it's also important to note that general administration includes carrying out activities to affirmatively further fair housing, and we anticipate a final affirmatively furthering housing rule to come out sometime this summer, so that will be a very important use of trust fund dollars. Like with home and CDBG, there is a distinction between general program administration and so-called project administration. Project administration being the staff and overhead directly related to carrying out a specific housing development. The interim regulations allow jurisdictions two options in this regard. Program administration can either be considered as general program administration and therefore subject to the 10% cap, or as just project costs and not count against that 10% cap. Developers and states will have to look very carefully at this on a project-by-project basis. When the proposed rule came out in 2010, HUD made it very clear that trust fund money could not be used for public housing. When the interim rule came out, we were quite disturbed because HUD had changed its mind. The interim rule says that trust fund money can be used to rehabilitate public housing that is being converted under the Rental Assistance Demonstration, or RAD. Currently, 185,000 public housing units are being converted from public housing to either project-based vouchers or to project-based rental assistance. HUD is constantly seeking to eliminate the cap altogether so that all 1.2 million public housing units would be eligible to use National Housing Trust Fund dollars. In addition, the interim rule allows trust fund money to rehab or build new public housing if that's part of a Choice Neighborhoods initiative or if it's part of a mixed finance public housing project that entails the low-income housing tax credit. This is very problematic. The intent of the National Housing Trust Fund was to add new units that were affordable and available to extremely low-income households. These provisions regarding public housing do not add to the stock of housing that's affordable and available to extremely low-income people. In a sense, it's substituting trust fund dollars for public housing dollars. We don't want to have trust fund dollars substituting for home or public housing. And you as advocates, we would hope, would work to ensure in your state's allocation plan a provision that would not allow for the use of trust fund dollars for public housing or to substitute for home dollars. And finally, some key timeframes to know about. The law requires that trust fund money be committed within 2 years. The interim rule defines committed to mean having a legal agreement with a recipient for a very specific local project then that can be expected to begin rehabilitation or new construction within 12 months. In addition, the interim regulation requires, as I said before, all trust fund money to be actually expended within 5 years. And that concludes part 4. Periodically check our website to see if there's new information that we've been putting on our website. Check with HUD's website. HUD will be producing a lot of guidance in the coming year. If you have questions, please write or call me. Also submit comments and suggestions. Tell us how it's going in your state or your locality. And if you're not a member of the National Low Income Housing Coalition, please consider becoming one. Thank you very much.